1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်430 ဥပ A and 1 appellants vs ဦးမြိုင် and 1 respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Appeal before ဦးကျော်ဆန်းဦး Judge ဥပ A and 1 appellants vs ဦးမြိုင် and 1 respondents Code of Civil Procedure Section 47 Read with Section 2 whether executing court can alter, vary or add to the terms of the decree. Hell, where a decree in terms of a compromise is passed against persons who are parties to it, the decree is binding against all persons against whom it was passed unless and until set aside by appropriate proceeding. Its validity cannot be challenged in execution proceeding. It has been universally held that the executing court cannot alter, vary or add to the terms of the decree. It cannot go into the question whether the decree was obtained by fraud. The executing court cannot embark on an inquiry into facts which, if established, would show the invalidity of the decree. The established rule that an executing court cannot go behind the decree is, however, subject to certain well-defined exceptions, viz. If the decree is 1. Against a dead person or 2. Passed without jurisdiction or 3. In contravention of an enactment based on public policy. Uba A for the first appellant. Uba Jo for the respondent. Ujozan U Judge. This is an appeal under Section 24 of the Rangoon City Civil Court Act arising out of Civil Execution Case numbered 206 of 1963 of the City Civil Court Second Judge of Rangoon against the judgment and decree date 29 April 1966 passed under Section 47 read with Section 2 of the Code of Civil Procedure. In Civil Regular Suit numbered 557 of 1959, the appellants obtained a consent decree on 14 October 1959 against the respondents for payment of Jet 5,000 with costs amounting to Jet 709.50 on condition that on obtaining a registered power of attorney as per original agreement between the parties from the respondents to find a suit for adjustment of the tenants from number 5 Ukwe Street, Sanjiang, Rangoon, Uba A, the first appellants, original second plaintiff should find the suit and give possession of the house, but on failure to comply with the condition imposed upon the respondents, the appellants, plaintiff decree holders would be entitled to have the decree money with no such condition attached. In Civil Regular Suit number 65 of 1960 of the Rangoon City Civil Court, Uba A, on behalf of Myang, the first respondent, who also represented his minor son, the second respondent instituted a suit against one Teng Ang, a tenant of the premises for a judgment, but on 16 May 1962, the suit was dismissed without cause as settled out of court, and half the amount of court fees paid was refunded to the appellants plaintiff under Section 28(1) of the Rangoon City Civil Court Act. The order diary does not show on what terms the suit was settled. In Civil Regular Suit number 76 of 1960 of the same court, also UPA, on behalf of the respondent, obtained a decree on confession without cause for a judgment of the other remaining tenants of the same premises on 23 January 1963. In Civil Execution Case number 206 of 1963, out of which the present appeal has arisen, the appellants applied on 19 February 1963 for payment of $5,000 and costs against the respondents in accordance with the terms of the decree, and in default for attachment of the building and site in question, viz. number 5, Ukui Street, Sanjiang, Rangoon, stating that the tenants have vacated and UPA had delivered possession of the premises to the respondents. The respondents' judgment debtors contended that the decree for payment of $5,000 in favor of the appellants' decree holders was in reality in respect of the another cause of action and not in respect of the cause of action shown in the suit, which was a suit, Civil Regular Suit number 557 of 1959 for the recovery of $5,000 as appellants' purchase money. The consent decree was for payment of the same amount with costs, with the condition advantageous to the respondents that the appellant UPA must find a suit or suits for a judgment of the tenants residing in the suit premises and, after adjudging them and giving possession of the premises to the respondents, on his first obtaining a registered power of attorney from the respondents for the purpose of filing the said suit. UPA has stated in the application for execution that he has complied with the condition imposed. The respondents admitted in the objection that UPA did file Civil Regular Suit number 65 of 1960 for a judgment of the tenants in the City Civil Court of Rangoon, but the suit was settled out of court at the instant of the first respondent, judgment debtor, and not at the instant of UPA. It must be remembered that UPA was representing the respondents and his registered power of attorney had not been cancelled then. In the objection, the respondents, through their advocate, raised other new facts which ought to have been raised in the suit itself. They are irrelevant here. The respondents never denied that they have obtained possession of the premises. Their main point is that the appellants are not entitled to $5,000 and costs. The burden lay heavily on them. The consent decree was never set aside on ground of fraud or illegality, and it still stands to this day. The advocate for the respondents, defended judgment debtors, contended before me that the decree obtained in Civil Regular Suit number 557 of 1959 is illegal, but in view of the decision in S.A. Nathan vs. S.R. Sampson 1, which say a subsisting decree passed by a duly constituted court that has not been set aside in proceeding by way of appeal, revision, review, or otherwise by due process of law is not to be treated as a mere nullity, but is binding and conclusive against the parties thereto duly impleaded in the suit. This point, which was also raised in paragraph 2 of the written objection in the lower court, was abandoned. This authority was followed by the late Supreme Court in Kazin, Jiwat, and another vs. the Mumbai municipality too. The lower court held an inquiry under Section 47 Code of Civil Procedure, and in its judgment date 29 April 1966, it went into the full face of the suit and said that there was no supporting evidence to show that there was a balance of 5,000 due to the appellants from the respondents as purchase money. Under Section 2 of the Civil Procedure Code decree, which follows the judgment shall be deemed to include the determination of any question within Section 47. I do not understand how the lower court could reopen the suit when a consent decree had already been passed in it. It said it was difficult to hold that 5,000 was the balance purchase money. It gave the decree and subsequently it said it was not a legal one. It held that it was impossible for the appellants as decree holders to recover the 5,000 as decree, and whatever it might be, it was not possible to determine that the appellants had solely carried out the condition imposed on them as per decree and dismissed the application for execution. Each party was ordered to bear its own course. It is indisputable that the court executing a decree must take the decree as it stands and has no power to go behind it or to entertain an objection to the legality or correctness of the decree. An application in execution assumes the validity of the decree sought to be executed. If it is competent to a judgment debtor to raise in execution questions as to the validity of a decree, there seems to be very little reason why he should not question the propriety of the decree and thus rebut the whole proceeding. I am of opinion that this is not a procedure allowed by law. The executing court will be traveling beyond its competence if it allows the judgment debtor to raise question of fact on proof of which it might appear that the decree sought to be executed was a nullity or an illegal one. The court is construing the decree and not considering its merits. Hence, where a decree in terms of a compromise is passed against persons who are parties to it, the decree is binding against all persons against whom it was passed unless an ante set aside by appropriate proceeding. Its validity cannot be challenged in execution proceeding. It has been universally held that the executing court cannot alter, vary, or add to the terms of the decree. It has been universally held that the executing court cannot alter, vary, or add to the terms of the decree. It cannot go into the question whether the decree was obtained by fraud. The executing court cannot embark on an inquiry into facts which, if established, would show the invalidity of the decree. The established rule that an executing court cannot go behind the decree is, however, subject to certain well-defined exceptions, viz., if the decree is 1. Against a dead person, or 2. Passed without jurisdiction, or 3. In contravention of an enactment based on public policy. These exceptions do not arise in the present instance. In Shankar Rao and others, first, Reg. Hu Net Rao 3, cited by the respondent's advocate, it was held that there was no appeal against the order discharging the defendant respondents from the suit under Order 1, Rule 10(2) of the Civil Procedure Code. It had no relevance to the present appeal. In the result, the appeal succeeded and the judgment and decree of the lower court dismissing the application for execution are set aside with course with the direction that execution shall proceed forthwith according to law. I make no order as to advocate fee in this appeal.